is that prior to giving the statement, he informed the officers that he didn't want to talk to them without a lawyer. They simply ignored that request, continued to talk to him, and then he ultimately gave a statement. Now, the concern we have is that the trial court in its order seems to state or suggest, depending on how you read it, that there's no evidence that Mr. Claxton was coerced, therefore there's no concern with the statement, meaning because he asked for an attorney is not enough, or at least that's how I understood that the ruling to be. It's he asked for an attorney, they continued the conversation, but the conversation continued without coercion, without them standing over him, yelling at him, or I guess outwardly intimidating him. I don't believe that that's the law. I don't even believe that's relevant. I think what's relevant is that after he asked for an attorney, the interrogation should have stopped. Of course, Mr. Claxton testified to this. No one actually refutes that fact pattern. There is no one saying that's not what really happened. The whole contention is, well, there was no coercion during that conversation. I don't believe that that's the standard. And again, I think that alone would be sufficient. The other issue we raised, it almost goes hand in hand with the totality of the circumstances, but I did raise it as a standalone issue as well. Mr. Claxton explained that he received an offer from his attorney of 13.5 years and that he wanted to take that offer. And then he was unclear about why he could not take it. From what he understood, the attorney, his trial attorney, was trying to state that it would be under the charge of aggravated assault, and that the trial court explained, well, aggravated assault is not a lesser included. He had no idea, meaning the appellant, why he couldn't take it, what the miscommunication was and what the concerns were. But I think it's telling because it goes towards the issue of the appellant, at that time the defendant, having a right to be a part of his litigation and having a right to accept an offer or have his case resolved in that manner. The fact that he could not receive the offer, accept the offer, and will admit it is unclear as to what happened. The trial attorney is deceased, but we know from speaking with the appellant that he attempted to accept this offer. He was not able to accept it. To me, there's too many unknown questions when the only two people a part of that conversation is the appellant and the trial counsel, and the appellant doesn't know the law. He's not a lawyer. He doesn't know what any of what he was being told meant. I think that's rather concerning, and I think that alone, separate and apart from the totality of the circumstances, shows that there clearly must have been ineffective assistance of counsel. And I think that if nothing else, that also would be a standalone reason why this should be remanded for a new trial. The other issue, which I think is also extremely concerning, was that the defendant in this case was forced to testify against himself. Specifically, he was required to stand before the jury and put a bandana on his face and hold a gun. Now, the issue initially was raised by trial counsel. There was an objection. The trial court then said, what is your objection based on? Trial counsel, I don't believe, remembered or knew the rule, and so he withdrew it. That is a concern. Clearly, the appellant was being required to testify against himself. That clearly goes towards Tennessee Rules of Evidence 801, where it tells us that a statement can be, under number 2, a non-verbal conduct of a person if it is intended by the person as an assertion. There is no scenario where this appellant, who was not exercising his right to testify, should have been forced to get up in front of the jurors and in essence testify. And I don't understand how the state could have invoked that right against the defendant to his detriment, and I don't understand how trial counsel could not have protected the defendant from that conduct. I think that is an egregious, flagrant error that should not have occurred. It is not proper. It is a violation of Rule 801, and that should not have been withdrew. The argument of trial counsel should have been, this is a violation of Rule 801.
So Rule 801, the hearsay exception, right?
Yes.
Okay. How do you respond? What's your best argument to the state's response that what they had your client do was not testimonial?
Yeah, I would say that I disagree, because what it is designed to do is it's basically putting an image before the jurors and the witness and basically telling them, based on this conduct, which could be a form of a statement, does this basically refresh your memory or allow you to believe that this is the person who was engaged in those actions. It would be the same as if you were charged, and again, because these are emotional, these are very serious charges. If I was charged of taking someone's little baby and slitting their throat, and they said, well, Mr. Tootin, do this for me. Stand before the jury, hold this dowel and hold this play knife and slice it across their throat and invoke all those feelings and emotions and say, does that look like the person who did that or the conduct that did that, and ingrain that into everyone's head and then turn around and say, well, no worry, Mr. Tootin, your rights were protected. That wasn't testimony. Doesn't hurt you one bit.
But in every case, I mean, a witness, normally the victim, is asked to identify the defendant, right?
Correct. And he could do that without the defendant. So it's one thing to say, identify the defendant, and they say, hey, I think it's that guy there. I think it's Mr. Tootin. It's another thing to say, wait a minute, the guy had on this mask and this. Mr. Tootin, put that on, pose that, and then stand in that pose, pretend like you're running away. Is that what the guy looked like? That's totally different. That's forcing me to do something that I did not agree to and that I'm not asking to do.
But that's how the victim saw the perpetrator,
Yeah,
right?
but he saw a perpetrator. To then turn around and make the defendant have to be the one to put this stuff on and do this conduct is improper, is what I'm saying. It would be the same as if you couldn't take another person out of the audience and then just stick them up there and say, we're obligating you to do this demonstration. They specifically picked the defendant because they were ingraining something in the jurors about this conduct being from the defendant and inflaming them and using the defendant himself basically to help convict himself. And that's where we have our concern. Would not have had a concern if they just said, look around the courtroom, tell me if you see the person. It's bad enough that it's always going to be the guy sitting behind the trial counsel who they're expecting you to identify, but we've learned to accept that as defense attorneys, that that's part of the thing that happens, regardless of how they look around the court inquisitively as if they're really thinking about it before picking the person right behind the defense attorney. We get it. It's another thing to make the defendant have to get on and do this whole charade in front of the jurors.
Remind me the scenario under which, was there somebody was on the witness stand testifying?
My understanding, and then the state asked the defendant to do it. The defense counsel objected.
Right, okay.
The state then said,
Let me
hey.
back up. So, and this witness was being asked to identify the shooter, a shooter.
So my understanding was, and I don't want to misspeak, I'll let the record speak to it. My understanding is that they were asking the defendant to put on the demonstration while talking. So they were talking about what happened first, and then saying, well, how were they dressed, and did they have this, and did they have that, and then turn around and had the defendant to put the
And
mask
so was
on.
this witness then asked to identify the defendant as the person that was the
He
shooter?
ultimately did, yes.
But only after he put on the
I believe he may have done it as well before. I believe there was conversation about it before, and I don't remember the
and the
timing.
witness
If it was,
identified before?
I believe that he may have, there were already conversations about it being the defendant, and I don't remember if they pointed him out first and then did it. And so let me be clear, I didn't get, and this might help, I did not get the impression that they could not identify him, and then they saw that and said, oh, I get it. What I'm saying is, I got the impression from the record they believed it was the defendant before that. Before that demonstration, my position is you should not be forced in to do that demonstration to ingrain it with the jurors, because just because you believe it, the jurors are the ones who are going to ascertain credibility.
So it's really not an identification issue. What you're really saying
Correct.
is that it prejudices the
Correct.
defendant
I don't
in front of the eyes of the jury because he had to put on
Exactly. I'm going to admit before the court, I don't believe that that was the difference between identification and not identification.
Okay.
But I believe it was still a form of testimony, and it actually bolsters his testimony against the jurors, using the defendant against himself. And then the last major issue I raised is that Jeremy Gray was not impeached or not allowed to be impeached based on his prior charges that were pending, which were extremely significant charges, aggravated robbery and kidnapping. The defense was not able to go into that at all. That makes no sense. The rules allows you to go into this for one, so there's no basis why he should not have been able to go into it. It also goes directly to credibility. It lets you know the type of person you're dealing with, and it also goes into whether or not this is a self-defense issue or concern, knowing that the propensity for violence that this person engages in, and the jurors are the triers of fact who gets to weigh all that information. It is no way that that information should have been excluded, when in addition the defendant is being forced to parade around with his mask and wave a gun around, and all those things in the totality, individually but as well as in totality, makes it extremely concerning. This is not conduct that should have happened. But again, there's no justification as to why you can't question a witness of this. This is a material witness. This is the key witness. This is the guy who's saying, I'm the one who was the target of this assault, attack. This is something that credibility comes significantly into play. And not being able to give the jurors a full and clear background of who this person is, who they're listening to and talking to, is important. And so I think for those reasons, we'd ask that this case be remanded and that he be allowed a new trial. Unless there's any more questions, I will be back.
Thank you. General?
Good morning, Your Honors. May it please the Court. Ray Lapone on behalf of the State of Tennessee. This Court should affirm the judgment of the Post-Conviction Court because the Court in this case actually found that the petitioner failed to prove by clear and convincing evidence Strickland deficiency and prejudice as to all the claims. And as an initial matter, the burden of presenting evidence at these hearings rests with the petitioner. And the first thing the court found in its very detailed order, which Your Honors have, was that there was merely no proof other than the bare assertions of the petitioner in his self-serving testimony for the court to consider merit as related to any of these claims. Taking the claims in order that the petitioner presented them to the court, as it relates to the motion to suppress, there was just no evidence put on other than the petitioner stating that he told Sergeant Wilkie, who had interviewed him, that he wanted a lawyer. And that was essentially what he testified to. And then he just used the word coerced. And the court found that the petitioner bearing the burden of proving whether or not, and keep in mind what we're talking about, Your Honors, is trial counsel's performance as it relates to whether or not to file a motion to suppress in the case. And they've got to show, of course, you've already heard the three prongs as it relates to when you're going to attack an attorney's performance when he or she is handling a case as it relates to filing a motion to suppress. You've got to show that the suppression would have been successful. Certainly that it was not objectively reasonable based on what the trial lawyer was facing to not file one. And why is that important here? Because as the post-conviction court found, there was no evidence. They didn't put on Sergeant Wilkie. They made some allegations about a 48-hour hold and how he asked for an attorney, and that the statement was coerced. But other than his statements, the court had nothing else to rely on. And if Your Honors look back at the court's ruling, you will see the court was also the trial judge said, well, all I really have to look at, and he went back to the trial record, looked at Sergeant Wilkie's testimony at the trial, how he was arrested, how the petitioner was Mirandized. So at that point, really, when you're talking about deficiency on Mr. Copeland's part for not filing a motion to suppress, there's just no proof that he was deficient. In addition to that, you look at the facts of the case. What was the lawyer when he made this decision? Now, granted, Mr. Copeland was deceased, so obviously we did not have his testimony for the post-conviction court to consider. But the petitioner here gave a statement, admitted, and was self-serving that he was in fear for his life when he shot. And in fact, that the intended victim, Mr. Gray, was out looking for him before he fired shots into this basketball court. So obviously there's a reasonable inference there that one of the reasons that he wouldn't have filed, he being the trial counsel, a motion to suppress, is because he knew the petitioner was going to testify in this case. And he did. And he explained to this jury that he was in fear for his life, and obviously the jury discredited his testimony. As it relates to this 13.5-year offer, Your Honors, there's simply no proof that that ever happened. And we would argue also that it's waived relying on the Holland case. If you notice in the court's order, the court didn't address it in its order because it wasn't in any of the petitions that petitioner filed. Now, granted, at the hearing, he did testify to it, and the state was able to cross-examine the petitioner as to this 13.5-year offer. However, the court didn't rule on it. And the Holland case seems to suggest that, yes, you can have a claim make it out of the post-conviction court if it's not in a petition, as long as the testimony was presented to the post-conviction court at the hearing, which you have. But here, the court never ruled on it, so we would argue that it's waived. To the extent it's not waived, there's just no proof this happened. The petitioner didn't even put on a prosecutor or anybody to say that this was ever offered. And as your honors know, the law as it relates to deficient performance of trial counsel as it relates to plea negotiations, they've got to show, or at least the petitioner has to show your honors, and certainly the post-conviction court, that the court would have accepted the offer, that the offer was actually even made. And the post-conviction court had nothing to support this claim, keeping in mind you're talking about whether or not Mr. Copeland was deficient for not pursuing a 13.5-year offer.
Was there anything in the record typically done at the trial or before the trial where the trial judge asks defense counsel, defendant, have there been any plea offers in this case? Was there anything in the post-conviction record that addresses that?
And yes, Your Honor, you're absolutely correct. Ordinarily, in front of a trial court, if there's been an offer conveyed, and certainly the defendant or petitioner in this case isn't taking it, usually that's put on the record. Certainly the state will rely on the record, but it would be our position that there is nothing in the record. The court didn't even have anything in the record considered to prove that this 13.5-year offer happened. And to Your Honor's question, he really doesn't even say, if you look at his testimony at the hearing, that it was an offer he was given and then turned down. He just says that Mr. Copeland, trial counsel, came back, discussed the 13.5-year offer, mentioned something about aggravated assault, and then the next thing you know, he claims, and nothing in the record to support it, that the court said or told trial counsel that, well, you can't plead to aggravated assault. This is a criminal attempt first-degree murder case, and somehow trial counsel is deficient at that point. And that's really all that was before the post-conviction court, which is why the state submits, the court found that that claim did not show deficiency and certainly wouldn't show any prejudice as it relates to Strickland. And this third claim about the demonstrative evidence, first, and certainly the state will rely on the record, but the state would submit that this occurred when the defendant was testifying. So he was actually testifying. And it was the state who, during cross-examination, had a reasonable basis because they had a bandana. There was a .25 caliber weapon recovered, and that's also consistent with one of the shell casings at the scene, whoever was shooting into the basketball court. And so what happened at that point, a lot of the victims and witnesses in this case who knew the petitioner, knew who he was, said that he had something covering his face, a bandana or something. So that was consistent with the testimony that the state was putting on at the time. So what the state asked the trial court for permission to do is, well, we would like the jury to see, can you identify somebody if you know them with a bandana over their face and then hold the gun, which was the .25 caliber pistol I think they recovered. And what the post-conviction court said, first of all, trial counsel did object. And then the trial court pretty much let the trial lawyer know, what's your basis for that? Because the court's going to let this in because demonstrative evidence, and I think the law is clear, and I think we cited the Pillow case. There's numerous examples, Your Honors, where trial judges have allowed demonstrative evidence, And this court, among other courts, have held that it's non-testimonial. Now, granted, a line can be crossed, but we would submit here it wasn't. But if we're getting back to trial counsel's performance, and I think one of the things that was challenging to respond to the petitioner's brief in this case is a lot of these claims come under this umbrella of ineffective assistance of counsel, but when you really get into the arguments, they're not even attacking trial counsel's performance. Several of these claims are strictly just disagreements with how the trial court ruled on the admissibility of evidence, whether it was allowing the demonstrative testimony on cross-examination. The lawyer objected, but the post-conviction court made it clear that even if he would have had another basis for objecting, that was still going to happen in this trial. So how do you then say that trial counsel's performance falls below the prevailing professional norms when he objected the best that he could? So we submit there that under Strickland, this is not ineffective assistance of counsel, regardless of how that happened during the trial. And as it relates to the impeachment of Mr. Gray, again, sticking to the prongs of Strickland, attorney's performance, deficiency, and prejudice, when you look at what happened there, they had a 609 hearing. The record will show Your Honors that. The trial lawyer engaged in the hearing, and the trial court evaluated the juvenile record of Mr. Gray. And in that juvenile record, there were several adjudications where the delinquency was sustained, which would be like a conviction if he was an adult. There were pending charges against him as a juvenile. I believe it was aggravated robbery and aggravated kidnapping. So they had a hearing. And trial counsel argued what trial counsel could, and the court allowed impeachment evidence on two of the sustained prior delinquency charges. I believe there was a theft, so there was crimes of dishonesty there for impeachment, but made it clear that under 609 doesn't permit impeachment from pending cases. He hadn't even been adjudicated of the aggravated robbery and the aggravated kidnapping. So again, trial counsel's performance certainly not deficient there, had the 609 hearing. This sounds like, once again, petitioner is attacking the trial court's decision to not allow impeachment as it relates to those pending juvenile offenses. And when Mr. Gray testified, he was in jail clothes. The court notes that in his order, and the reason why that was important to the post-conviction court is if you're trying to show some type of prejudice because the trial court didn't allow impeachment by the petitioner on these two pending juvenile offenses, well, the jury saw him in jail clothes. The jury heard that he had prior delinquent sustained offenses. So how do you show prejudice as it relates to the outcome of the actual case where he confessed to firing two weapons into a crowded basketball court with teenagers running for their lives, 3 injured, 1 shot in the leg, 1 shot in the right calf, 1 shot in the back and the neck? How do you establish prejudice just based simply on the court's ruling? And as it relates to cumulative error, the cumulative error, the state would submit, just as the post-conviction court properly ruled, that this petitioner has not met the clear and convincing burden as to any of these claims. And as Your Honors know, cumulative error talks about multiple errors where one by itself may not be enough to show deficiency or prejudice, but maybe an aggregate of errors might grant some relief. The state submits that there were no errors proven as it relates under Strickland, as it relates to this trial attorney's performance in this trial. And if Your Honors don't have any further questions, the state will rely on its brief for any remaining questions or concerns. And certainly, the state asks that your honors affirm the post-conviction court's judgment.
All right,
Thank you.
General. Mr. Tootin?
Just briefly, responding to opposing counsel, who I always enjoy his passion when he argues and disagree with his conclusions often as well. But first, when we're talking about the statement as far as there being no prejudice, I want to be clear. Anytime you give a statement against your interests and it's having you in your committee or you're admitting to a crime, that is a prejudicial thing to do. So any characterization of otherwise, we would disagree with. The fact that the person was Mirandized, in this case the defendant, doesn't change the fact that him now knowing he needs to speak to a lawyer and he has to speak to a lawyer, that doesn't negate any of the argument we made. I think what's even more telling, which I don't even know if this actually disagreed with me, is this contention about this 13.5 offer, for 13.5-year offer. First, to say that the court didn't address it, that goes to our point. This is a concern. There's a problem here. It should have been addressed. But even more specifically, which again does not sound like we're disagreeing here, it was the trial court itself that was a part of this conversation. And even during the post-conviction hearing, the defendant was telling the judge what role he played in this conversation about what the judge said. Judge doesn't deny this. Judge doesn't get an order and say that never happened. So now we have this other awkward scenario that we're looking at. The judge now is basically, based on what I think we both agree, at a minimum a material witness. So it's a little unfair to say that we didn't present the right evidence when he's saying, Judge, you were right there, this is what was said and this is how it went down. The judge doesn't deny it and then doesn't address it. I don't think that that's something that we can say, yep, you failed to meet your burden on that, defendant. No, what else could he do? Can he subpoena the judge to talk at the hearing? No, the judge was at the hearing, he addressed the judge. The judge was also the person at the trial, and that I don't know what else he could have presented. And then this argument about impeaching somebody on pending cases in 609 doesn't allow that. I agree. 609 doesn't allow that, which is why we went under 608B, which does allow it. It talks about prior conduct or conduct that you can be impeached for. So again, that is our issue. And then this other argument about, well, a lot of these issues is not actually the trial counsel as much as it's the rulings or the things of that nature, that falls under due process. And what we're saying is that the trial attorney was ineffective at the trial and appellate level not to flesh these issues out and raise them. And that's under the totality of impact, where we specifically, starting on page 13, explain how this is also due process and is ineffective counsel. And again, so that I'm clear, if a trial counsel tries with his best heart and he is not effective, when it relates to the defendant, that is ineffective counsel. This is not an argument to say, but he tried hard, he meant so well, he's a really good guy, I'd let him watch my kids. None of that's relevant. What's relevant is, was he effective? No, if you're not effective by default, you're necessarily ineffective. So with my...
Mr. Tootin, just so I'm clear on this, you are standing by your position that all of these claims come under ineffective assistance of counsel?
Yes.
You're not, I thought you said during your other
Yes.
argument that these were standalone claims.
So they are, but they're twofold. These are all examples of ineffective assistance of counsel individually. If not individually, then totality. And then in addition to that, there are due process violations that the trial counsel and appellate counsel was ineffective for raising and preserving and getting across the finish line as well. So we're arguing all of the above. We don't want to leave anything off the table. We want you to agree with us at least on one of those, if not all.
You usually don't leave anything on the table.
Thank you.
Good job.
All right, thank you. All right, need a break? Yeah, all right.
All right.
We'll take a recess for about 5 minutes.